Okay, it's 11 o'clock. Let's get started. Welcome from New York. I'm Ellie Noam, the uh, director of the Columbia Institute for Teleinformation, which is sponsoring this. Bill Drake, our director for international affairs, is and policy, is the organizer of the session. Jason Buckwitz has managed everything, so thank you for everyone. Let me start out with a few introductory comments that I usually make. Uh, a panel, any panel that runs for an hour and a half, is that, and one of the problems is there are always some voices missing, inevitably. And so one of my roles, and actually a reluctant one as a host, is to supply some of these voices. And for this topic today, it would be the voice of skepticism. Sometimes people on the inside of an issue are maybe too close to the issue. In fairness, I'm not really on the outside. I take AI seriously. I'm just finishing a book on AI in video media. I just did an article on AI and its resiliency problems and the threat to it, not just by AI, but also to AI, and therefore to societal systems clustered around AI. But even so, I'm amazed at the global efforts to deal with AI. There are all kinds of regulatory initiatives right now, international efforts to coordinate these initiatives. I'm dizzy from the acronyms of all the organizations that have initiatives and conventions and proposals and principles. OECD, UNESCO, UN Secretariat, ISO, CENELEC, IEEE, EU, and now Council of Europe and the declarations, Hiroshima, Bletchley, and I'm sure I'm missing half of them. So my question is, why all this energy? Why are we doing all this? Is this just a bunch of policy intellectuals and bureaucrats who have cut their teeth with privacy and some related issues and now need a shiny new thing to get involved with? What have been the concrete, not the hypothetical problems that have emerged? And where problems did emerge, and I'm sure they have existing laws not been enough and regulations? Does technology help to mitigate existing problems? Before we jump to international treaties and conventions, let's think about that. So when I hear about AI, as I mentioned before here, I think of it sometimes as a global ink blot test. Tell me what you think of it, and I will tell you who you are, your fears and hopes and fantasies. And that goes for individuals, for countries, for governments, for agencies, and for distinguished commissions. Because AI is so sprawling and so multidimensional, because of that, you can pick out almost anything. And so we've been flooded with negative scenarios, inequality, bias, digital divide, employment, nuclear war, inadvertent economic crisis, et cetera, et cetera. And some of this will be true. But is this, in fact, the reality, or is this a fear? Even among experts, for example, the note, yes, it is true that some AI fathers, such as Jeffrey Hinton, have been sounding alarming voices about AIs and the future threats. But other fathers of AI, such as Jan LeCun of NYU, have basically said AI today has the intelligence of a cat. That doesn't sound terribly threatening. But I think it goes deeper because I think there's this evolutionary fear that is in our DNA of that species that will take over, the wild animals, the dragons, and the aliens from space, and now it's AI. And so we should perhaps kind of like a little bit go easy on our fears and understand that they're natural, but not necessarily realistic. And that AI, in fact, can also be the tool to protect us against bad AI. Good AI protects us as a personal assistant, as a firewall, as a selector of information, et cetera, et cetera. Now, I'm not going to be kind of a Pollyanna about it. Of course, there will be a problem. But when you rush before a problem actually emerges into regulation, and not just on a national basis, but now also on international conventions, it's time just to kind of look at it realistically and see, are we a little bit kind of ahead of the curve here? Which gets us now to today's discussion, which is the initiative by the by the Council of Europe to deal with AI. We have a wonderful panel, and we have a great moderator, Bill Drake. Take it away, Bill.
Thanks, Ellie. That was fun and provocative, and I think we'll probably respond to some of those points as we go. So welcome, everybody, to the third session of the semester, academic semester. In this webinar series, we're in our third year. We've covered a lot of topics over the past few years, and videos and transcripts of the previous sessions are on the website that is linked from the announcement if you're interested in seeing what we've done before. Our next meeting will be in late January, and we'll be convening to talk about the WSIS Plus 20 review. So let's turn then to what Ellie was just talking about, the sort of AI governance frenzy. There is clearly an explosion of governmental initiatives and intergovernmental initiatives around AI, trying to set out different types of frameworks. And we see this at the national and bilateral level, at the regional level with the EU, the African Union, ASEAN, at the plurilateral level, bodies like the OECD, the G7, the G20, the AI safety institutes and their summits, and the multilateral level where you've got the UNESCO has adopted recommendations, you've got the UN General Assembly making declarations, you've got the new Global Digital Compact arrangements that are being set up, including an independent scientific panel. We talked about this at a previous webinar. So this is all, to me, like it kind of echoes what happened with internet governance 20 years ago, but on a larger scale. There's sort of a frenzy of governance activity as people try to figure out what is the problem and what needs to be done. And as Ellie suggested, it's kind of a Rorschach test phenomena where people are projecting their hopes, dreams, and fears onto the space, and that shapes a lot of the discussion. With the exception of the EU regulatory approach, the European Act, much of this initial international work is focused on setting broad normative guidelines and sort of risk-oriented guardrails around some issues, questions of safety and ethics, and so on. And we'll get into some of these other initiatives in the course of this year in the webinar series. But I think it's an interesting development. And in this context, yes, we wanted to start with the first international treaty around AI. And this is with the Council of Europe, which has been an interesting organization, very involved in international human rights issues for a long time. And of course, has played an important role with regard to questions like cybercrime, where they had the Cybercrime Treaty in 1981, which has been a very important international treaty, not just for Europeans, but there's, I think, 76 parties from around the world, including the United States, that have endorsed it. The Council of Europe is an early mover in this governance sweepstakes. In 2019, it had for 2 years an ad hoc committee on AI that scoped out the issues, and then that was followed by a formal committee that was established in 2022 that spent 2 years negotiating and came up with this agreement that we're going to talk about. It's worth noting at the outset that the ambition was to set an international kind of framework. So the negotiations included not only the Council's 46 members, but also the European Union and 11 states, including the United States as non-member observers, who had a very active role and were quite influential on the outcome. Other observers included 68 civil society and industry representatives that participated in the plenary sessions, not the drafting, I guess. And they had adopted a text in May 2024, which was open for signature in September. And the US was one of the first to sign, although whether it will actually ratify the agreement, given its current political situation and its history of relationships to human rights agreements, we'll see. In any event, we'll delve more into the substance in a few minutes. Let me just say a couple of things by way of quick introduction to set the table for everybody. First, in terms of the focus, the agreement is not about regulating economic aspects of the AI industry, market structure, and so on. It's about democracy, human rights, and the rule of law. It does not create new international human rights or obligations, but rather seeks to apply existing ones to AI, is technologically neutral, is not tied to particular systems, et cetera, So it's flexible in that sense. Secondly, it sets out a set of guiding principles, 7 guiding principles, which we'll be talking about, which are applicable across the board. Establishes a framework of remedies, procedural rights, and safeguards, including the ability of people that have been negatively affected to be able to lodge complaints and so on, and seek some adjustments. And it sets out a framework for risk and impact management. Unlike the EU Act, I should point out, it doesn't categorize risks into baskets and try to specify regulations for each. It leaves that to the national level, to the way governments are going to implement. But it does call for carrying out risk assessments, and there's been subsequent work to try to develop methodologies for how you do risk assessments. I think an important point to flag at the outset, and this goes to Ellie's point about the private sector and so on, is the scope of coverage. This has been highly controversial. So the convention covers the use of AI systems by public authorities, including private actors acting on their behalf. So states are the bound parties. The convention does not directly regulate the private sector, but what it does is say that when regulating the private sector, to whatever extent they do, national governments who are signatories, who have ratified, can choose either to directly be obliged by the framework convention, or can opt to take other kinds of measures to comply, such as relying on self-regulatory or voluntary efforts. This is a sort of opt-in approach that was insisted on by the United States, in contrast to the European Commission, which wanted an opt-out kind of approach. So the obligations are binding on states, but they're free to choose how to achieve these. And each state party has to declare within a couple of years how it's going to go about trying to address these issues, and whether it's going to rely on self-regulation or something else. The convention also exempts national security, defense, and R&D, things that are important to talk about, I think. And finally, it establishes a follow-up mechanism. There's a conference of parties, as is often the case with such treaties. It should be noted, I guess, that this is a framework convention. And if people are not familiar with framework conventions, this is increasingly used in the environmental field and other areas, where you got basically a 2-step process where you have a first binding set of general obligations and principles, and then you set up a mechanism to further elaborate protocols and so on for particular regulatory issues. And as I say, the council is already working on some of that with risk assessment issues. So the reception to this has been interesting, and we'll talk about that. The private sector wanted to be, the American private sector wanted to be exempted completely, and basically got that, at least from the United States side. Views from civil society, many were critical of certain aspects of the agreement, but now I think we're seeing a lot of endorsement and efforts to try to get people to join. So there's a lot going on here. This is a very interesting initiative. First out of the gate, as I say, for international agreements, hard agreements in this area. So there's a lot to explore, and to do that, we have a panel of people who have been closely involved, including centrally involved, I would say, in the negotiation process. We have Omar Bitar, who's a senior policy advisor at Global Affairs Canada, where he advises Canada's foreign policy on the global governance of digital technologies like AI. Omar was part of the Canadian delegation that negotiated the Framework Convention, and he previously served as a policy advisor at the Treasury Board of Canada. We have Christabel Randolph, who's Associate Director at the Center for, by the way, he's joining from Canada. We have Christabel Randolph, who's Associate Director at the Center for AI and Digital Policy in Washington, D.C., where she oversees U.S. law and policy work, and involved in congressional committees and policy agencies and so on. She led the organization's efforts with the Federal Trade Commission to establish guardrails for AI services. And her center has been a particularly prominent player from the civil society standpoint in the discussions around the convention. And finally, we have Thomas Schneider, who is Ambassador and Director of International Affairs at the Swiss Federal Office of Communications in the Federal Department of the Environment, Transport, Energy, and Communications. Thomas was actually the chair of the negotiations in the Council of Europe's Committee on AI. He also was the vice chair of the OECD's Committee for Digital Economy Policy from 2020 to 2022, and was the chair of ICANN's Government Advisory Committee from 2014 to 2018. He's represented Switzerland in a number of international fora related to digital governance, has been coordinator of the European IGF since 2008, a coordinator, and he's joining us from Switzerland. So that's our team here. And what we're going to do, as always, is have 3 to 4 rounds of tour de table around some general questions to get the conversation going. And then around the top of the hour, open it up to broad group discussion. We see a lot of people here who have joined who are expert in these areas. So I think we should be able to have a lively and vibrant discussion. So I'm looking forward to it. And thanks everybody for joining. So, okay, with all that said, then let's start with just the descriptive basics. Maybe Thomas, before we launch into the panel discussion, you could say a few words about why you did this in the Council of Europe rather than some other setting, and you know, the sort of broad impetus and orientation of the convention. Just share a few thoughts with us.
Yes, thank you, Bill, and hello everyone. I'm very happy to be with you tonight in my timeline. Maybe just allow me to quickly react on Ellie's initial question. I think everybody's talking about AI for 2 reasons. One is because people of my age that grew up in the 70s and 80s, we have all seen movies like Terminator 1, 2, 3, or no matter how many there are, with our good friend Arnold Schwarzenegger. So we have some expectations about what good and bad AI can do. That's one element. And the other one is, it was, I think, why things have become hottest on the table of many politicians is because people like Elon Musk and others that signed that letter when ChatGPT came up and said, this is super dangerous, we have to pause. This is, of course, an excellent PR move to bring the issue that you're dealing with on the top of all politicians and all the media's agenda, by saying this is super dangerous, so you must be very cautious, and then say, but we are the experts, so trust us, let us handle the job for you. Everything will be fine as long as you trust the right people. So this was, of course, an excellent PR move. It's a little bit provocative, but I think that, of course, was not by accident that those that signed that letter, at least some of them had this motivation. So, and now we're talking about AI. We are not talking about data governance, which is at least as important, but we are talking about AI because it's easier to connect AI to something frightening than data, which is more abstract. About the question of the motivation, the Council of Europe is a unique organization that has features that no other has. And if you give me a minute to explain what the Council of Europe is, it has got nothing to do basically with the European Union. The Council of Europe is a UN for Europe. It was also created after the Second World War, trying to prevent Europeans from going at war and killing each other. We more or less succeeded until 2 years ago. And it has used to have 47. Since 2 years, it has 46 member states because we had to throw one country out because it disregarded all fundamental values of the organization. It is, as you say, it is not an economic, it hasn't an economic component, it doesn't have a military component. It was created to protect and promote democracy, rule of law, and human rights, which are considered, let's say, the fundamentals for peace and free and solidary societies in Europe. And over time, it has developed instruments that actually can go beyond geographical Europe. It can include other countries from other continents that share the same fundamental values, and which is what this what is important in this context. You mentioned there's a cybercrime convention, there's a convention on data protection. The first one is from 2001, the other one from the 80s has been revised lately, where between 50 and 100 countries sign up to a binding framework to respect some rules, to agree to some procedures for international cooperation. And this allows basically to have agreements where in the UN you would not have a consensus, or you would not have, even if you had a consensus, you would not have the means to actually more or less reasonably in a believing way, in a credible way, enforce something. But you don't want, but you may have states that have an interest in a trustworthy regulatory framework, also internationally, not just in Europe. And this is why, for instance, the US was among the countries that was pushing very much for the Cybercrime Convention because they had an interest in fighting cybercrime also with other countries from other continents. And data protection, the partners are somewhat different. The US is not a member there, but many other countries like Canada are. And in the case of AI, also there was a sense that while the European Union was working on a law for their own jurisdiction for the digital single market of the 27 EU member states, there was a sense that it would be good to have an agreement on how to deal with AI, also to facilitate economic cooperation among so-called like-minded countries from all around the world, which means that, and the Council of Europe has the opportunity as the only institution basically in the world to offer a treaty-making framework with a more or less credible implementation framework as well for countries from all around the world, as long as you fulfill some minimal requirements on rule of law, democracy, and human rights. So not, and it's any country can apply to be part of this, but there's a decision by the 46 member states whether or not they would accept the country. And there's some countries in the world that would probably not be acceptable. But we did have not just the big G7 players like US, Canada, Japan, as part of the negotiations. We also had one of the leading AI countries, Israel, for instance. And we also had some countries from Latin America, Mexico, Argentina, Uruguay, Peru, others. And we are also in contact now with countries from Africa that are willing and interested to join this framework. So it's a scalable framework where you can go ahead with like-minded to create some institutional and legal certainty, but you cannot be blocked by the ones that do not share the same goals or shared interests. So it's something that is between a regional institution and the global institution. And the most important thing, and which was part of the challenge, in Europe, of course, we do not have exactly the same institutionalization of a human rights law, for instance, like what you have in the US. Europe, because of the Council of Europe, that if you are a member of the Council of Europe, you have accept that there is something like a European Court of Human Rights, where any citizens from any of our countries can appeal to the Court of Human Rights in case he thinks that his state doesn't protect his human rights enough, also vis-a-vis activities by the private sector. And so this is fundamental, that we have a higher level of protection, higher so-called positive obligations on European states, because they can be challenged by citizens before the court, which is something that in other continents doesn't exist. And that was one of the big challenges for this convention. It would have been easier for us to create a Europe-only convention, because then we could have relied on this legal system that we have as members of the Council of Europe. But then we would have been limited to the member states of the Council of Europe. And it was a political decision by not just the Council of Europe members that we wanted to have a convention with a global reach. And this is why the negotiations were a little bit more complicated, but hopefully the instrument is more powerful. Thank you.
Thanks, Thomas. And just a reminder to everybody to please mute your mic, except for the speaker, because we're getting crosstalk. So let's start with the conversation with top level assessment. So as the question that was posed in the announcement for the event, there's different ways of thinking about this, and this goes back to Ellie's point too. I mean, one is to say this is an important and needed achievement for the world. Another is to say that it's an example of regulatory overreach, as some free marketers might assume, for example. Or you could also argue, as some might, that it's unlikely to have significant effects, that these kinds of normative human rights type things end up not really impacting behavior all that much. So what I'd like to ask people to do on the panel is to sort of dig into that question of, is this an important thing? And if it is, then how do you reply to the possible criticisms that could come from other quarters? Why don't we turn it around? Let's start with Omar. We'll just go alphabetically. So Omar, why don't you go ahead?
Thanks, Bill. And hi, everyone. Glad to be here. Glad to be part of this panel. To the question of I guess, how to assess the treaty at a top level. I mean, I would say as the first International Convention on AI and Human Rights, as you suggested, and as Thomas mentioned, I think the treaty can be considered historic in that sense. Specifically as a framework convention, I think it provides ample flexibility to states and how to implement its obligations. So different states will take different approaches, whether policy, legal, or otherwise, to give it effect. Because of that, I wouldn't say that it's an example of regulatory overreach per se. It will, of course, be some time until the effects of the treaty can be evaluated. But the fact that we landed on an agreement that has already brought the US and the EU to the same table, or potentially will do so down the line, but also attracted interest from states across Latin America, Africa, and the Pacific, I think is a unique achievement. So I think we should assess sort of the outcome so far on that basis. And then again, wait and see how the effect of the treaty will play out as states start to ratify. I'll stop there. Thanks.
Okay, great. Thanks. Very concise so far, so that's good. Christabel, your thoughts?
I echo what was said by Ambassador Thomas and also Omar, and we really think it's not really a regulatory overreach, because if you look at what's happening in global AI governance, even preceding the adoption of the treaty, there has been overwhelming consensus that there needs to be global cooperation and collaboration for AI governance, especially because if you look at data sets, data, the digital ecosystem, the entire AI supply chain, it's not concentrated in one country or one region. It really does require global cooperation. You know, you mentioned the G7 countries, and we've seen countries from Asia Pacific to Western Europe to North America interested, participated. The Center for AI and Digital Policy, we've been part of the CAHI, the first ad hoc drafting group, and then part of the CAI. And we are currently doing a global campaign. We've also called on Canada to ratify it, and we're reaching out to other governments and other observer states as well as, and really continuing this education, because it's about collaboration. It's not about overreach.
Okay, fine. Thanks, Thomas. Your reply. I mean, obviously you think it's an important agreement, but what I'd like you to address is the possible criticisms, that either it's overly expansive in its effort, or that it's unlikely to make any real difference, unlikely to be implemented in a way that impacts concrete behavior.
Yes, well, first of all, I leave it up to others to judge whether this is something that actually makes a difference or not, or it's over or under, or regulating or reaching. I think the intention was to have a very basic framework that would help let's say, like-minded countries that share the same fundamental principles to cooperate politically, but also, of course, to facilitate innovation. And this is the other bullet of the mandate, is to create something that safeguards human rights, democracy, and rule of law. And the bullet number 2 is the instrument should be conducive to innovation. That was the task that we've been given. We'll see whether that works. But as Omar has also said, it only establishes a number of very basic principles. 7, you've named them, or you said the number, and it does not create any new rights. That means its aim is to make sure that the existing human rights, the existing protections for the democracy and rule of law, are also applied in the context of AI. And this was a challenge. It tries to respect that we have, or it has to respect that we have different protection levels and different ways of dealing with human rights. So a right to privacy is not the same in the US like it is in the EU, like it is in Switzerland, like it is, I don't know, in Japan or in Africa. So it tries to do this margin walk to say a member state or a signatory state is not obliged to boost the rights or create new rights, but it just needs to make sure that these rights, the way they are now, are also, or they may involve in a country, are applied equally to AI as it is to other technologies.
So it's setting sort of a normative floor in a way, a common kind of baseline, and states can go further or so, right? So the principles, I mean, let's talk about how you would implement. So you've got principles like human dignity and individual autonomy, equality and non-discrimination, respect for privacy, transparency, oversight, accountability, reliability. These are pretty standard sorts of principles that we try to see built into most international agreements around digital and issues, and they are obviously very central to human rights. A government then would have to implement, a government has to establish mechanisms that it says, this is how we're going to go about achieving those principles. And here's the kind of mechanisms we put in place in terms of procedural rights, remedies, etc. What is it not possible, though, that in setting that framework, that some governments will be very loose in their interpretation of what they actually have to do, and perhaps not really do much at all? I mean, isn't that part of the possible mix of considerations here? Any thoughts from any of you about that? I mean, the skeptical point, that because there's a lot of people who when they look at normative kind of agreements like this, they just say, yeah, it's nice on paper, but nobody's going to do anything concrete. So how do we actually see that working in terms of implementation and tracking the implementation and encouraging compliance? Any of you? Thomas, go.
Try to be short. Well, this is a challenge for all international treaties, because also the Council of Europe, even if you sign up to a binding treaty, there is no Council of Europe police that comes to chase or puts a president in jail because he violates the treaty. But unlike the UN or other institutions like UNESCO, when they agree on binding treaty, again, the Council of Europe has a human rights court where a country can be accused or condemned of not respecting what it signed up to. And if you look at the Human Rights Convention, also freedom of expression, now these are 5 lines. So the basic principle, normally, if they are supposed to stand a few years, they're normally very general, but then you have an explanatory report that goes along with the convention, which goes a little bit into more detail. And then you have the legal tradition of soft law that has been taken into account. You have court decisions. And again, there's a difference. In Europe, you can take a government to court. In addition to the only mechanism that all have is the so-called Committee of the Parties, where the countries mutually assess each other in the way that, okay, countries have to show how they are implementing the convention, how they think they are living up to the requirements, and then the other countries assess this. And of course, if all countries violate the convention, they will put the bar very low to be accepted. But if some countries take it more serious than others, they will put pressure on the others to boost up. So this is the implementation is what it is, but it goes further than most of the other international institutions that elaborate treaties.
The Council of Parties mechanism and the mutual surveillance and reporting seems to be an important part, and that's true of any kind of normative agreement, right? If you just adopt a normative agreement and walk away, then nobody's keeping track. If you set up a framework for ongoing dialogue and reporting about compliance and non-compliance, and people are talking to each other and raising concerns about cases where violations have occurred, then you could create some pressure, right? Do either other two, Christabel, or would you like to say anything about this?
Yep. So because we look also very closely at the US AI laws and policies, it's interesting, you offered a provocation at the beginning of the talk that there's a carve out for national security, but we also have a national security memorandum, which was issued not too long ago in the US, just about a month ago, which calls out clear red lines. So even though as an observer state, the US delegation did speak on behalf of carving out national security, but the government itself has issued memorandum that binds the federal government and agencies in terms of prohibited AI use cases. And this interaction between soft law and hard law is something that has to be monitored. At the center, we do this Artificial Intelligence and Democratic Values Index, and we every year review like 80 countries and how much they've progressed in terms of aligning their AI policies and systems with human rights principles. And it's an interesting and looking over that the last 4 years, you do see interesting progression and you do see the needle moving. It doesn't happen overnight. It's not that you sign a treaty, people go, they enact laws, they set up courts. Exactly. But it's important to track this over a period of time. And as Ambassador Schneider said, that this the sort of peer review process, so to speak, that is present through the Council of Europe is very effective, even if you look at aspirations for collaboration, aspirations for, leadership. The US, Europe, all are talking about Asian countries, China, everyone's talking about AI leadership. And also, if you look at the fact that there are geopolitical concerns that might motivate more collaboration than competition or conflict.
Yeah. Omar?
No, I mean, great points so far. I would just maybe take the point on the Conference of the Parties one step further to point out that the treaty establishes a reporting mechanism in relation to the Conference of the Parties, where the parties actually have to come and report on how they're implementing it in the public and private sectors. And I think we can sort of be reassured of it that can help with that mutual accountability, that transparency that states will bring to the Conference of the Parties. And again, given that international law has limitations when it comes to enforcement, I think we can at least have a reporting procedure for all the states that are involved to come and say, hey, this is how we are doing this in X or Y country. And it may be effective, it may not be so effective, but at least there's that mechanism. So I think that's one response to the skeptics, so to speak.
Right. And it's not just the intergovernmental process. There's also, as Cristobal was saying, the civil society groups and others that will report. And so the naming and shaming thing is multidimensional. And when people don't comply manifestly, you can then apply some normative pressure on them to try to come into alignment. So that's certainly the way these things get done. Let's try. Cristobal mentioned the national security thing. Let's talk a little bit about the sort of carve-outs and also the important point about the scope. I mean, it was a highly controversial issue. Many in civil society jumped up and down and were very unhappy about the ways in which the private sector's role was addressed here. There was a lot of statements, particularly from some European and I would note Swiss NGOs that were saying that there should be uniform, comprehensive application of these rules to the private sector directly, rather than simply to the governments in their interface with the private sector. So one of the questions I think is to ask, what are the implications of not uniformly applying a set of mandatory obligations to the private sector? I mean, this is clearly a domain within which companies are the drivers, right? I mean, governments play a role in how this stuff is getting implemented in certain environments, but much of the innovation and the application around AI is being driven by companies, in particular large companies, but not only. And so there's real questions about how you can hold the private sector to some account in this framework. Could you guys maybe address that? Thomas, you want to start and we'll just go the other way?
Happy to start. First of all, also I think there are a few things that we need to consider. That basically it is the duty of a state to make sure that rule of law, human rights, and also democracy is protected and supported. It's not the legal obligation normally of a private actor.
Mm-hmm. Right.
So then there are various degrees of what in Europe we call positive obligations, or there's a German word, Drittwirkung, that of course private actors may also lead to violating human rights, to the damaging democracy, but then it's up to the state to develop a regulatory framework that creates incentives for private actors to respect human rights. And we have an important soft law instrument on global level, which is the UN Guiding Principles for Business Conduct, but this is a soft law instrument. And whereas the US wanted to be on the safe side and have this not at all apply to private actors, and the EU which departed from its market regulatory logic of its own law, wanted to have this all in one. For instance, the Swiss delegation, of which I was not formally part of, said, we want it to be broad in application, so risks and impacts caused by the private sector should be addressed, but they should be addressed in a different way. And I stopped there just saying, for instance, as a government, if we as a government administration, we do something, whether it's using AI or not, you need to have a legal basis for it, whatever you do. If you do something you don't have a legal basis, people ask you like, you don't have a legal basis, so you're not allowed to do it. With the private sector, it's the other way around. Normally, companies do whatever they want unless there is a legal basis that restricts them. So also the setting and the logic and the responsibility is different between private and public actors. And we actually do think that this is a reasonable solution that we have. So the convention says you have to address both, but it leaves it up to the state according to also the tradition and the expectation that its citizens have on the state to regulate or not, or to guide private sector on how you address it. But you need to address it, and as Omar has said, you need to be transparent about what you do, how you do, and then leave it up to the others to be happy or not, or to tell you that you don't do enough.
Christabel, you want to, but in particular, like, because you work with a civil society organization, I mean, I was really interested in the fact that, you know, in the context of the negotiation process, civil society people were jumping up and down and saying this is totally inadequate. Basically, you're allowing the United States to basically opt out, and there'll be no real effective, you know, governance of what business is doing. And they wanted uniformity, but now civil society groups are saying everybody should sign the agreement. So I'm very interested in sort of the view from that side about how they see the private sector treatment.
So firstly, we at the center, we see the treaty as a success, right? It's very important that we now have a globally agreed baseline on safeguards, and agree with what Ambassador Schneider said, that the obligation is really on governments.
Call me Thomas, don't call me
Yes. As Thomas said, it's really upon governments to ensure that democracy, human rights, and rule of law is protected. At the beginning, we, of course, were part of the group that called for as comprehensive a baseline as possible. We also sent a letter to Secretary Blinken, and we engaged closely with the US delegation as well in terms of, you know, the carve-outs and scope. However, we also understood that the government leadership and the public sector leadership here is very crucial, and that's really what can align and set the tone, or so to speak, set the rules of the road for private sector. And at least in the US, we see that happening. We see that happening with the Biden executive order. We see that with the procurement guidelines. We see these principles that are reflected in the Council of Europe AI Treaty translate into various executive instruments being discussed in various bills, not just in Congress, but across states, to establish those mechanisms. So yes, it did not come comprehensively in the treaty text, but it's also important to see how it's being reflected. And when we talk about implementation, if it is being extended through the different mechanisms, through the different texts, through the different instruments, then of course, and we are part of that process. We are part of the continuing advocacy process, not just for states, more countries to sign and endorse the treaty, but also, especially in the US, tracking how the principles are being incorporated into implementable instruments.
Okay, great. Omar?
Yeah, I guess I'll just start by saying, or I guess reiterating, that I think the scope, you know, in principle recognizes that action is needed in both sectors. I think that was an important political message to send, especially in the current environment. So there's that. I think, I mean, the way to think about this is that, you know, the outcome really reflects a compromise that will secure the treaty's appeal and its global reach in the long term. So I guess, you know, there's a trade-off here between you know, the ideal scenario, and I guess a scenario that will attract, you know, the most number of states and maybe have the most impact in the long term. And I think we've already seen the fruits of the outcome, where we've seen, the US and EU sign and come to the same table, and also other states. And I'm sure we will see more in the coming months and years as well. So I think that's one way to look at sort of how the scope discussion played out and how to assess it. In terms of the impacts, I think states will have several ways to meet the obligation, the private sector. So I expect to see some diversity in how parties actually apply the treaty in that respect. So some will choose to implement it as is. For example, Norway has declared as such, and the EU may do so given how its AI Act functions. And others will opt for their own sort of unique approaches, which may take policy, legal, or other forms. So I think, to kind of reiterate your point, and maybe Thomas said the same earlier, is that, there's bound to be some diversity now that we've established some kind of normative baseline, and that's okay, I think, for such a nascent regulatory space where there remain not only, let's say, ongoing efforts within national context, but also a lot of concerns around how to balance, the effort to mitigate risk with the imperative for supporting innovation and ensuring actually companies, particularly SMEs, are not overly burdened by measures. And then finally, I guess I'll just repeat my point that in addition to this public-private arrangements, we have that reporting mechanism, which I hope will serve as an additional layer of protection, so to speak, or an additional layer to make sure that we at least hear about how states are implementing the treaty, both in the public and private sector. So that'll provide, again, a bit of a transparency and accountability mechanism.
Okay, that's great. So I'm sure you guys don't prefer to deal in hypotheticals, but I'm going to ask you to do it anyway, because I want to pick up further on this point about the diversity, the flexibility of the agreement, and the diversity of possible implementations and how that might work. So, okay, let's say Norway says, we are going, in our implementation of this, we are going to require all private sector companies operating in Norway in the AI space to comply with some mechanisms, and we're going to have regulatory or other policies that we establish to that effect. And then the United States says, well, it's going to be the Trump administration. So they say, well, we're just going to do nothing, or we're going to say it's voluntary and companies can do whatever they want. AI is the companies involved are operating globally. They're operating across national frontiers. Data is flowing globally. The scope of all these things is going to be global. So then how does that how would that play out then? I mean, how would it actually work in terms of, okay, you've got some countries that are saying, within our jurisdiction, within our territory, we'd like companies to directly do X, but other jurisdictions, particularly big ones, are saying, it doesn't matter. So how does that then work in terms of safeguarding human rights, democracy, rule of law, Thomas?
Yes, well, I think first of all we have to just accept the fact that the world will not fully harmonize in all details ever, because we have different cultures, we have different histories. Sometimes it's warmer or drier or colder in a country and more or less fog, and these things have an effect. And you may have different neighbors also, or no neighbors if you live on an island. And so there's of course also a geopolitical component behind this, that the uniting element was to have something that some countries want to prove that they live up to some standards of respecting rules compared to others that are considered maybe less reliable, also when it comes not just to human rights but also to rule of law and other things. So and of course in Europe, and just one word about the carve-out on national security. In Europe, in Brussels, the narrative was shared by governments and civil society that Europe are the good ones and Brussels and the US are the bad ones, and the chair and the Council of Europe has sold their soul to the US because they want them on board. In fact, in particular in the case of national security, it was not the US that asked for the carve-out. Maybe they were happy that somebody else asked, but it was not the US. that asked for the carve-out. It was actually countries from Europe. Just to make that one clear. So the narrative of good and bad ones is also was a little simplifying in that sense. But and I think it is a fact that in particular when it comes to privacy rights, we will probably not have a full harmonization between the US and the EU and also some other countries like Switzerland. And of course, Norway, because you cite the example of Norway. Norway is not a member of the European Union. They're a member of the Council of Europe, but they are a member of the European Economic Space Agreement, which binds them to the EU rules. So the EU rules are directly applicable to Norway. In the case of Switzerland, we are not officially part of this. We normally voluntarily take on most of it, but we can say no to some of the things. So also there, Europe, the geographic Europe is not a united bloc. And also, even if the EU has its AI Act that is fairly detailed and gives a lot of descriptions what to do and how to do, we are, of course, in contact with a number of EU countries. They need to implement this into their national jurisdiction, their national structures, and you will also have a diversity on how these things are implemented within the EU countries. Like you also may have some diversity in US states, even if there's a federal law, that doesn't mean that in Ohio things are exactly the same like they are in New York, because life is not necessarily exactly the same. So this convention is an attempt to help interoperabilize the logic, or harmonize the logic, the basic logic, but interoperabilize the ways that the logic is implemented. And it is also not meant to replace all the existing legal frameworks that you have internationally and nationally. And there will be new frameworks that are more sectorial, more specific on health, use of AI in health, or the use of AI in the automotive industry, and so on and so forth. So it's not a one-size-fits-all, and definitely not replaces all the rest and solves all of the problems instrument. It hopes to be a useful contribution to set the common baseline and help to have a shared vision of how to basically generally approach things.
It's always great when these webinars lead to the development of new jargon. So interoperationalize. Wait, how did you say it? Interoperationalize.
Well, interoperability is the buzzword in the last 2 years
Right.
on AI, because harmonization may not work. So yeah,
Right.
I'm not inventing this. This is all over the place. At least
I've never seen it with the eyes on it. Okay. So anyway, so
okay.
So Cristobal Omar, your thoughts on I mean, yes, diversity is good, as Thomas says, and in the U.S. we have different states with different policies. But what does it mean if, say, the U.S. basically does nothing while some European countries, or say Canada, try to strictly apply these rules to the private sector? How does that work? Or any thoughts?
So in the US, foreign relations law is actually quite interesting, and it's a world unto itself, and there are self-executing treaties, non-self-executing treaties. It's not just whether the US has signed it, it's an assessment that is carried out by the State Department, by the members of the Senate Foreign Relations Committee, to see how the US would meet its obligations. But it doesn't mean that there's nothing on the books. There are civil rights laws, there are consumer protection laws, there are federal guidelines that apply to the public sector agencies. And in the US, the US government is the biggest purchaser, has the strongest purchasing power, and that's where we are seeing the safeguards being put in place. That's very aligned with the provisions of the Council of Europe Treaty itself. So when we talk about implementation, I think looking at how that is being implemented and the diversity requires looking at different dimensions. And it's not that it will mirror word for word what is being reflected in the treaty, but are there mechanisms for enforcement existing currently? Yes. I mean, if you have AI systems that are discriminatory, that are violating the Civil Rights Act, we've already seen enforcement in those spaces. We're already seeing litigation in those spaces. So we are seeing, so I wouldn't be so pessimistic to say that just because there is cultural, geographic, political diversity, we will not see more the same kinds of enforcement everywhere. I think we would see the same kinds of enforcements. It's just that maybe the institutions or the time or the timeline of that enforcement may vary. But I think human rights across the world now, I would be pressed to find a country or a government or even the major companies that would say that they do not respect human rights obligations, whatever the product or service they're offering.
Okay, thanks. Omar, your thoughts?
Yeah, I mean, it's a great question. I think like the goal, I think, as I see it, is not really to produce some kind of regulatory uniformity across, what is a diverse group of states. I think that the goal ultimately is one way to think of it is to actually create a normative baseline. We've heard that said. Another is geopolitical, to actually bring democracies together for transatlantic and hopefully global cooperation, especially as we're seeing many examples of digital authoritarianism, many attempts to weaponize and abuse AI and other critical technologies. So I think the goal of this exercise and this initiative, isn't really to say, hey, states, come here and do things the same exact way. I think it's more tending towards building this kind of political alliance of states, I guess, hopefully from all regions or as many regions as possible, that actually at least agree on compatibility, agree on the idea that AI governance should actually take such and such principles as foundational or as a basis, and then respecting their individual circumstances, they go ahead and do their best in actually realizing that. And in doing so, I mean, that could also create downstream opportunities for trade and for economic cooperation, because where existing trade agreements are present, again, the treaty can provide a baseline for considering how to support mutual recognition of rules to facilitate trade. Where there are no trade agreements in place, I think this political cooperation can actually create opportunities for new trade and other forms of economic cooperation. So yeah, I would maybe reframe the purpose of it to say that we're not really driving at producing the same approach across the board.
Right. Okay. There's a lot of other questions I could ask, but I'd like to open it up. We've got other people here in the room with us, and I've seen several people asking questions or making comments in the chat as well. I would certainly invite them to turn on their microphone and camera and speak. But if they don't want to do that, I can also read questions there. But anybody with us who'd like to join in the conversation, please do. Just introduce yourself, say who you are, and then we'll go. While I'm waiting to see if anybody is going to do that, why don't I start by reading one of the questions in the chat. So Siva in India says, are there precedents of U.S. regulatory guidelines directives respected by Europe? And if so, do European regulatory conventions reciprocally respect the U.S.? And beyond the U.S., does the European regulatory trend have a noticeable impact in the rest of the world? This is your Brussels effect kind of question. In this case, the Strasbourg effect question. So he's asking about mutual sort of recognition between Europe and U.S. kind of agreements and the kind of wider extensible impacts. Any replies to any of those points from anybody? Thomas, sure.
Well, yes, there are, and I think there's a difference between what is called the Brussels effect, is where the European Parliament and government decides about rules for them, and then hoping or assuming that others will follow and take over their rules. Whereas in the Council of Europe, you have, although that they are formally called observers because they have no voting rights, but you have countries from outside Europe being equally participating, equally negotiating. So it's not an effect that you do something that has effect of others. You let the others into your house, have them sit at the table, and they develop something together. I think this is a formal This is an important difference. And in the case, for instance, of cybercrime, of course, there's a mutual interest to go after cybercrime in a cross-border way, and to have procedures in place that what data you can share among police institutions and so on. Also, then knowing that we have different levels of privacy protection and different rules. So also there, the privacy, and there were fears by civil society and others 20 years ago that the Cybercrime Convention would lower European data protection standards, align them to the lower ones in the US. That has not happened, but at least the European police institutions and security institutions know what can they share legally with the US without infringing the European citizens' rights and so on. And so this is a mutual, let's say, wherever there's a shared interest between countries from different regions, the Council of Europe offers a forum where they can sit together and try and agree something that is acceptable to them. And just one point, I think what we should not forget, and also some of the criticism that civil society and others had in the process, the people sitting at the negotiation table, the governments, they are not free. We all need to present this treaty to our parliaments. And if parliamentarians say, well, this is too bureaucratic, or this is not conducive to innovation, will not let our government sign this treaty. The people can't sign the treaty. So you have, as a government representative, you come in with some red lines that are given to you. And this is also what happened in this. And then at first you have red lines where there's no space where they meet. So you have to work on the red line and see to what extent can you redefine them or find ways that the red lines are respected. And this happens whether it's transatlantic or whether it's in another way international. There needs to be a mutual interest, and the willingness needs to be there to find the common ground where both sides or all sides can say, okay, this is fine. I may actually get this through my parliament to accept it, because otherwise it's of no use.
All right. Christabel or Omar, you want to get in on this point?
I think the US and EU have had the Trade and Technology Council for a while now, where they really collaborate on these issues, right? And that's there. There are other forums of collaboration. The G7 process has the International Code of Conduct, which actually agrees about obligations of private sector actors. The US tech companies have taken on voluntary commitments provided to the Biden administration, and the readout from the White House says that in the absence of the federal law, these commitments will be considered as enforceable. So would that necessarily be equivalent to a national legislation passed in Europe? No. But does that provide a basis for taking the conversation of influence, implementation, and enforceability forward? Absolutely. So again, I think there is a little bit of nuance and a little bit of broader perspective required in understanding the interplay between collaboration and the baselines that are being agreed.
Right. Omar?
Yeah, I mean, I would just refer to those multilateral forums where the US and EU work together. I mean, when it comes to AI, the main ones to think about are the G7, where, as Christabel mentioned, there's been endorsement of a number of initiatives on AI. Most recently, the Hiroshima AI process, led by Japan and built on by Italy this past year. And so that's an area where I guess US, EU, and the rest of the G7 have been working together on a normative basis, and of course the Hiroshima, as some on the call may know, involves a code of conduct which is intended to actually apply to developers of AI or advanced AI systems. So as that evolves, we could expect to see some convergence between US and EU and the rest of the G7 for that matter, on best practices, if I can call them that, or relevant practices for industry, particularly industry that is in the advanced AI space. Beyond that, I mean, I think there are other examples, the OECD, the Global Partnership on AI, the G20. I think there's a number of multilateral forums that have made significant contributions to the global landscape, where the US and EU have endorsed the same thing or worked on the same thing.
Yeah, and the AI safety institutes and those summits, I think, are going to be important in that. I mean, I think all the work with OECD, G7 is going to be consequential to some extent. Christabel, you had up, but then I just wanted to come back to something, but go ahead.
Yeah, very quickly, I wanted to talk about the AI Safety Institutes and the network conference that happened in San Francisco just a few weeks ago, where even Kenya participated, and all of these safety institutes agreed to develop common standards for testing the systems, to share their results and share that knowledge. So yes, there is work happening in this space.
Yeah, Gina Raimondo was very proud of that, it seems. But, you know, to see this point, though, the rest of the world aspect here, one of the things we saw with the Cybercrime Treaty of the Council of Europe is that a lot of countries that, even though, as Thomas says, the door was open and people could join in as observers, a lot of countries that didn't participate then subsequently said, well, we don't want to sign on to something that we weren't part of the negotiations. And of course, then you had the Russians driving the whole discussion into the UN, and we ended up with this terrible cybercrime treaty that, for some reason, Western governments are now signing on to, which I guess is going to be decided in the UN General Assembly this month, right? But I mean, presume that's going to go forward. There's always the rest of the world kind of question with these kind of processes. So if you look out 5 years from now, how do you think the same kind of thing could play out here, where maybe developing countries or other countries that were not part of the process come in and say, there's something about this framework we don't accept, and therefore we want to go to another direction, or are we not concerned about that? Thomas, yeah.
Yeah, and that actually also had, I saw that somebody was asking about creators' rights in the chat, and it actually happened quite often, and copyright and so on, authors' rights is also one of the elements where you had the so-called Basel Treaty at the Council of Europe in the 50s, which then decades later led to some WIPO treaties. So again, the Council of Europe offers an opportunity to go ahead among those that are willing to go ahead, and those that are not yet there or that have completely different views. You don't have to take them in, but they can also not block the others go ahead. And many times that opens the door for something that is more global later. And yeah, with the Cybercrime Convention, we can't go into detail, but also, for instance, Brazil, which is a proud country that normally doesn't sign up to something that they haven't been part of, they are now thinking also of signing the Council of Europe Treaty. But the other thing is that in addition to the 70 or so countries that have signed up to the Cybercrime Convention in the last 20 years, it has some, let's say, influence also on other countries, on more than 100 countries that may not officially sign up to a Council of Europe Treaty, but they are, let's say, maybe to 80, 90 or even more % identical or compatible with the treaty. So it's not just black and white with the ones that are officially in the cooperation activities and the advising that the Council of Europe does, and others, and all those that are part of the community of the ratified country, that also helps others to some degree. So it may be that sooner or later there will be global agreements on AI. There may be global agreements on sectorial elements of AI, and when you get this in all the sectors, in aviation, when AI is used to calculate, I don't know, flight routes or weather forecasts and so on. So through technical standards, through product safety standards, through sectorial legislation or self-driving cars, if you want to sell cars across the world, you may have to have some harmonization, interoperability between different types of car regulatory regimes, whether they are technical or infrastructure regulation and so on. So things will go on. If and when we will see a global AI treaty that has more or less the same reach like the Council of Europe is one thing. But then again, also, I'm not sure whether the UN Cybercrime Treaty will replace the Council of Treaty, because yeah, one thing is to write down some things on paper, and the other thing is actually to have the instruments to give it some credibility and more or less enforceability. And this is, of course, still very much in the open with the UN, with that UN cybercrime thing that is in the making or in the adoption phase now.
Yeah, and I just want to echo what aspect of what you said, Thomas, that often these kind of agreements that are reached by smaller end groupings do have a generalizable impact on other parties outside the grouping, because they configure the policy space, they configure the market space, they configure the behavior of the firms, and so that even parties that do not end up formally agreeing to something end up having to live in the space that's configured by what was reached in a smaller grouping, which is part of why these things can often, stuff that's been done in smaller groups like OECD can have larger implications, etc. Either of the, Cristobal, Omar, you want to get in on this point, the kind of second order impacts or extension, whether this could become, how it affects rest of the world and so on?
With regard to rest of the world, the Brazilian Senate just 2 days ago passed the text of its artificial intelligence law, which is mirroring the risk levels in the EU AI Act. So we're already seeing these ingredients spread. And if you look at really the developing world and a lot of the countries in Asia, Africa, we see the UNESCO recommendation for AI ethics, which was, by the way, adopted by 193 countries. And what UNESCO is doing now, they're doing a readiness assessment methodology and they're rolling it out for countries. And a lot of smaller countries that probably have not been active or really have little to no AI capacity are still participating in it, because it's a way of doing a status check of where you are and how you can be an actor. As you mentioned, these are digital technologies. Everyone wants to be connected and wants to reap the benefits. So we are seeing that the rest of the world being brought into this space. And there's really a lot of interest in AI. I think whether we like it or not, ChatGPT has made everyone very curious about what this technology is and how this technology can impact them, be leveraged by them. So we're seeing the rest of the world also, sort of catch up and pick up pace much faster than we've seen in the past with maybe other global initiatives or in terms of other global technologies.
Yeah. Omar?
Yeah, the main thing I would add, all great points so far, is that we've talked about how this treaty was negotiated with the intent or the ambition to become global, and has already seen a lot of interest, not just from Europe but beyond as well, and may further extend its reach in the coming months and years. I think all of this means that at a time when sort of AI divides between developed and developing countries, I think, are coming to the fore in almost any governance discussion we're involved in and we hear about. I wonder if the treaty down the line can become a platform, not just for the purposes of establishing a normative baseline, but also a platform to bring together developed and developing countries, developed and emerging economies to the same forum, to the same table, and actually contribute to the efforts to actually close that divide in capacity that we see in developing countries who are increasingly calling on states at the UN and elsewhere to actually to show demonstrable commitment to actually close that divide, whether through technology, through capacity, literacy, and other such efforts. And so one possible long-term or medium-term outcome, I guess, could be that the COE, if it manages to attract a large number of diverse states, could become that avenue, I guess, for capacity building and cooperation within the framework of the treaty.
Right. It's interesting that across institutional frameworks that we've seen emerging, you see a lot of convergence in baseline principles and norms. Right? G7, G20, the African Union's framework, over and over, you're seeing the repetition of certain core kinds of things, non-discrimination, equity, etc. These things are getting repeated in a way that maybe starts to build a sort of transnational normative baseline that extends beyond individual frameworks, and maybe that will lead towards some interoperability. Well, let's see if there's other people who want to get in on the conversation. I see more in the chat. Does anybody want to speak, though? If not, if nobody wants to, if everybody's shy today, Vinod says, how to make AI advances in medical diagnostics and treatments accessible to the greater part of the world? Are those regulations, are these regulations that hurt the goal? I think that's a good point. It comes back to this interface between human rights and sort of economic regulation. Is there any context in which, I mean, because we saw this from like the US private sector in their letter to the Secretary of State and so on, saying, you know, this will all be discriminatory. This will be another hidden European effort to be protectionist against American corporations. They're trying to suppress us and hold down our innovation. Is there any kind of scenario in which you would see the implementation of these frameworks impacting firms in a negative way from a regulatory standpoint, in particular with regard to the medical Vinod asks? Anybody want to tackle that question a little bit more? Thomas? You're usually not sure.
Yeah, thank you. Well, again, and this is also something that to people or industry players hesitant in Europe. I told them the treaty doesn't create new rights. Also, for instance, the funny thing about this carve out of national security, it says the convention doesn't apply to national security, but the general human rights are applied nevertheless like they have before. So if you have to then say, okay, the convention doesn't apply, but we need to respect human rights. We need to respect right for privacy, right to fair trial. How do you do that? You may end up in the field of national security. You may end up looking at the principles of the convention and use these because this may be the best available. So also this does apply, does not apply, because there's a history to all of this. There's a number of legal provisions that are already there that also apply to AI anyways. So yeah, it is not just about the convention. The convention is trying to make a few things more clear, make a few things more precise. And in particular, I think the value added on substance is not necessarily the principles, because they are fairly straightforward and not revolutionary new compared to other technologies. But the fact that you need to have mechanisms that allow a citizen to have access to documentation about an AI system that is used, for instance, when defining the years of prison that he has to go to, or how much social security funds he gets, or so. So this requirements to document these requirements for remedies and redress mechanisms, and the requirement to have a mitigation plan, basically in cases where negative impacts arise to people's rights or to democracy. These are things that are also not new, but they are specified. They help the regulators and businesses to know, okay, which kind of material will I have to document? What kind of log files do I have to create so that the rule of law actually still works? And I think so. This is one of the key, let's say, substantive values that the convention creates, that it helps people to see more clearly what it means to respect human rights, democracy, and rule of law in the context of AI.
Yeah, that institutionalization at the national level is a really key part. And it's one of the things, when people criticize normative frameworks, you know, I like in internet governance, through the internet governance negotiations, we saw governments around the world that didn't have any policy framework in place build up institutional frameworks and policies so that they can interface with the international, right? As well as manage their domestic stuff accordingly. And that's one of the things that I think gets driven here, is when you require those kinds of reporting obligations, et cetera, you'll see the build out of national mechanisms. But on the impacting the private sector point, Christabel, Omar, you want to say anything on that aspect?
So we've seen a lot of concern among governments in terms of provenance mechanisms for AI systems, and because of the concerns on deep fakes and how that impacts elections, how that impacts individuals in terms of deep fakes of themselves, and we've non-consensual intimate imagery. So, and there's a lot of regulation or intended regulation to address this issue. What do we see as a result of that? We see industries, we see newer players coming up that are offering these tools, that offering these provenance mechanisms, that's talking about, okay, how do we supply the technology that would do the voice fingerprinting or image fingerprinting? How do we make it accessible to the public and teach users how to use it. So yes, there is a regulation or there's consensus and discussion about regulation. There are some states in the US that have already legislated on, for example, deepfakes, and that attempts to create the specific product or service like an image generation tool. But surrounding that, there are a lot of other players also coming up that would provide the solutions to enable the regulation to be implemented. So when we talk about regulatory overreach and these kind of normative frameworks, one, yes, we see the institutional mechanisms that governments put in place to make sure they're implemented. But then we also see a private sector ecosystem developing to enable compliance and enable implementation. So it's not just that you're trying to constrain something from not happening, but it's also important to see how it's affecting and enabling new players to address this issue.
Right. Rules both constrain and enable. That's always worth remembering, right? I mean, stop signs both stop somebody from going, but they allow the other party to go. So there's a useful function there. Omar, just on that point, regulation is certainly an issue in Canada. So I'm sure this question's been debated a lot there.
Yeah, I mean, to your point, I think it's a false dichotomy to speak of regulating or innovating, so to speak. So I think the two go hand in hand. To the specific question in the chat, I mean, on AI advances in medical diagnostics, I mean, I think to echo Thomas, I think that the treaty addresses that kind of application. Where to the extent that it could affect rights, I think this is one area where we can see AI actually play a role in decisions that can affect people's fundamental rights. And so the treaty's practices, I think, can help build trust in technology being developed and deployed in the medical sector, whether diagnostics or elsewhere, especially if it's actually being deployed to make substantive decisions or even to inform them. So in that way, I think we can look at the treaty and any regulations that may flow from it or flow from countries signing up to it as helping really build public trust in those technologies, and as a result, actually helping the companies reach markets or reach consumers. And so, totally agree with you that these things, yes, of course, they could become burdensome in certain instances, but they can also enable by building trust, by actually building transparency, by letting the public know how a company or a government institution is using AI and why and for what purpose and with what safeguards. So I think all of that has to be factored in when we assess the merits of a regulatory or normative effort.
Right.
And I think without that, or in the absence of that, we, you end up with a lot of skepticism and I guess a lack of trust in the technology. And I guess we see some of that in some countries, including Canada, I guess, where the rate of AI adoption remains somewhat low, all things considered, and I'm sure that's the experience elsewhere as well. And of course, part of that is the novelty of the technology, the fact that many smaller companies are still figuring out how and why to use it and so on. But I think we also have to account for the fact that public trust and consumer trust plays a role in the decisions of corporations and other organizations in relation to adopting a technology. And I think that applies to the medical field as well as others. I hope that addresses the question, but I'm happy to expand.
Yeah, no, you did. We're going to move towards closure in a minute, but I see Siva has his hand up. So Siva, if you'd like to turn on your mic and or camera and say something, go for it. Siva, are you there? Yeah. If not, then, and I see Julius asking in the chat, I got the time wrong. Will the recording be available? Video of all these sessions are on the website. And usually we post them about a week after the event, but they'll be up.
Can I come in?
Oh, sure. Yeah, go ahead. Siva, go ahead.
Okay. So this is based on the observation that when Europe came up with GDPR, and then is legislating on NIS2, the business actors outside Europe kind of took notice and then try to change their business practices to comply with GDPR and NIS2. And can such a thing happen in the case of AI, in which the actors are much bigger and the scale of investments runs into trillions? And can Europe effectively or more effectively do something on AI?
So building on the GDPR precedent and the way firms have replied, I mean, I think we've kind of addressed this, but if there's anything in particular people want to add on that, building from GDPR to the AI experience in terms of companies comporting with the regulations? Thomas, you want to just give me a minute?
I can maybe combine it with something else. I mean, also with the GDPR, I think one of the big advantages or the successes of GDPR is, and it's been written in the chat, that it brought this to the attention. Whether the formalistic implementation of the GDPR, that basically before you access a website, you have to click I accept, and if you don't want to accept, you have to search for like how. So whether the implementation is actually, to what extent that is reaching the goals, is something that can be discussed. But of course, this, like it has said, this has several layers of effects. But I think also with regard to harmonization versus interoperabilization, whatever you call it, I think we have to acknowledge the fact that we have different ways of dealing with risks in society. Some cultures are more risk averse, others less. Other cultures build more on the people's ability to deal with risks themselves. Others build more on the state telling them, the administration telling them what to do. One example also between Switzerland and Italy, who are neighboring countries. In Switzerland, you have in car traffic, you have very, very clear speed limits and high fines. You have very strict controls of the technical quality of the vehicles, and you have strict controls of the drivers. You have less of this in Italy. But then if you go up a mountain road to 2,500 meters on the Italian side, you have a guard railing all along the street so that no car can fall down. And on the Swiss side, if you go down, and it can go down 1,500 meters, if you miss the street, you have nothing. You have only a small stone on the street. And if you miss that stone, and the stone is like this, then you may fall down 1,000 meters. In which country do you have more accidents and people dying? But in Switzerland, the control is like you control the key elements, and then you don't have to regulate and protect every street, every citizen in every occasion. Whereas in Italy, they have a different approach. The same with swimming in rivers. If you are in Liverpool, you have metal fences that are 100 years old, a second metal fence that was built 30 years ago, and another fence that have been to protect people from going into the water. In Switzerland, it's considered a quality of life to be able to swim in our rivers. So every year, some people die in rivers or die hiking up the mountains. But we don't want to forbid ourselves to do this because it's one of the best things in life. So you have to find other ways to deal with risk. So what I'm trying to say is that you will never be able to fully harmonize the approaches to how dealing with risks and innovation. And you will have to, that will always be there. There may be some, we are getting closer together with globalization, of course, but life will not be equal in the countryside and in the city, will not be equal at the sea or in the mountains. There will be some differences and your historic trust to the institutions will not be exactly the same. So there will be differences.
I think that's a good point to end on. And, having lived in Switzerland for 21 years, I remember being amazed to see Swiss politicians come out after sessions in Bern and take their clothes off and jump in the river. I was trying to imagine any American congressman jumping in the Potomac, and I don't think we'd be doing that. But anyway, listen, it was a very interesting conversation. Thank you all for your contributions. As always, I want to thank Jason Buckwhite, the Executive Director of the CITI, for managing the meeting's mechanics. I want to remind you again that we will reconvene in late January for another session, and we'll talk about the WSIS Plus 20 review. Stakeholder inputs for the review for the high-level session are due in March, so people are going to have to start to mobilize if they're going to do something meaningful there. So we're going to try and help with that. And I'll remind you also that the videos of these webinars are always posted on the website afterwards. So again, thanks everybody. And let me turn it back to Ellie for a closing thought.
Well, thank you very much, speakers, audience, and Bill and Jason. But in particular, the speakers from all over who have kind of volunteered their time and expertise. The more I hear about it, the more I think that one should kind of give careful attention to an approach that could be called a common law process of AI. AI is such a sprawling area, and just when we talked about medicine and some medical applications, it applies to in so many different ways, in so many fields, that I think that the approach of that omnibus approach, the ex-ante approach, is not going to work very well, but a common law type approach in which different countries, different agencies, different legislatures kind of graduate and court decisions contribute to a body of law, how to deal with certain type of issues as they emerge, would probably be a strong way to go. But there have to be some principles behind it. And so therefore, the approach that of a convention of Europe, say, or others to provide broad principles that courts and agencies then can flesh out seems to me kind of a positive contribution. More positive than specific pieces of legislation such as the EU type law, which already puts kind of something in place in a broad way, in an ex-ante way, in an omnibus way, that where there has been no experience and no careful thinking through of the specifics. And so with those thoughts, I will say goodbye to all of you and thank you again. And we will meet next month again. Thank you, Bill.
Thanks, everybody. Have a good one.